Good morning. Good morning. Hey, friends. Hey, Gail. Hey, Michelle. Working and lurking. You work and lurk, friend. Work and lurk. Hey, Gail. It's good to see you. I hope you're doing okay today. Hey, Henny. How are you, ma'am? You're lurking too? Lurking and listening? Lurking and listening. Let me put this banner up real quick. All right. Hold on just a second. I have the stream pulled up, ready to roll. And I feel bad for bringing this up, but I can't help myself. The prosecutor there, the comb over dude, watch here in just a second as he goes to sit down. He sits down a little too hard, and the top part of his comb over falls down, and he swooshes it back. I'm sorry. Rule number 5. Okay, first rule is if you are under the age of 65 or 75 or make it 85 years old, no comb overs for you. That's rule number 1. Shave that stuff. I wanted to say shave that ish, but I did not. Shave that right? Shave it. 2, if you're going to have the comb over and you don't want it to flip-flop, sir, spray it. Get some, some heavy-duty hairspray. I can't. That's very shallow of me. I know that was ugly. But man, I can't with him. I cannot with him. All right. We'll watch it, and then we'll probably rewind it and watch it 2 or 3 times before we get started. So, let's go. Let's go. Hey, Sherry. Did I say hey to Sherry? Good morning, Sherry. Now watch.
Please be seated.
Watch. There it went. And there it goes. I'm so mean. I'm so mean. Hold on. I have to... Okay, watch it. Did you see it? Watch. When he sits down, the front falls.
Seated.
One more time for good measure.
Please be seated.
I'm even trying to imagine him like after he wakes up in the morning and he slept all night. When he goes to answer if somebody, I don't know. I can just envision somebody knocking on the door and him getting up and not even realizing that he ain't looked at himself in the mirror, and he gets to the front door and opens the door, and then he's standing there in his bathrobe with this big, long, chunky hair just dangling every which way. I can't. One more time, and then we're done. I'm being so mean right now. Dude, stop it. I just spit. Did you see that spit fly?
Ms. Nichols-Cook, additional evidence.
Yes, Your Honor. The applicant would call Lynn White.
All right. Ms. White.
There you go, Michelle.
Take your time, please. You can come forward and have a seat in the chair to my left.
It wouldn't bother me so much if he was old. But he's a young guy. What? Oh.
There's no chair.
Yep, go ahead. Oh,
There's no chair.
our chair disappeared. Well, that's interesting. We can grab one from over here.
sleeps up. An old lady sleeps in an old lady bonnet. I don't know.
Thank you.
I mean, I don't have. My hair is no. You know, I do not have the most beautiful hair in the world either, dude. Okay. And I know I sling mine up on top of my head and it looks like a rat half the time. I look like a rat half the time. But
All right.
I don't know who
If you
this
raise your right
woman
hand,
is.
do you swear the testimony you're about to give will be true and correct?
Yes.
We're getting
You
ready
can
to
turn that
find out.
microphone on in front of you there. There's a button in the bottom center. And then feel free to adjust the chair and the microphone so that you can sit comfortably. Yep, okay.
What was the second time? Oh, I'm sorry.
Oh, feel free to adjust the chair and the microphone so that you can sit comfortably.
All right.
Okay, Ms. Nichols Cook, whenever you're ready.
Thank you, Your Honor. Good morning, Ms. White. How are you?
Good morning. Very well, thank you.
Can you state your name for the record and spell your name
Hey,
for
Ms.
the court
King.
reporter?
Lynn White, W-H-I-T-E.
Hello.
And Ms. White, how do you know Todd Mullis?
I am his older sister,
Sister.
And where do you currently live?
Dubuque County.
Did you grow up here in Delaware County?
Yes, I did.
And what do you do for work?
Currently, I am a office manager for a construction company,
How long have you been there?
14 years.
Okay,
Prior
go
to
lurk.
that, what did you do?
Get out of here, Michelle.
I was a city clerk treasurer for a small town in Dubuque County for 10 years, a neighboring county for 5 years as a deputy clerk, and I also worked in the banking industry for 5 years.
Do you have other siblings in addition to Todd?
Yes.
Who are they?
I have an older sister, Lori, an older sister, Mike, and the two younger boys, Pat and Todd.
And Mike's your brother.
Correct.
We've heard some references in other testimony about Lynn and Mike. Would that be you and your brother Mike that people are talking about as far as helping with things around the family farms?
Yes.
And then is Leroy Mullis your dad?
Yes.
Do your parents and your brothers all live close to where Todd and Amy Mullis were living in 2018?
Yes, all within about 5 miles.
And does your family, including your parents and your brothers, do they currently farm?
Yes.
Have they always farmed?
Yes.
Is it crops or livestock?
Both.
Both. In the spring of 2018, do you know who was planting crops?
Todd planted the corn and Mike planted the beans.
And in 2018, do you know who would harvest crops?
In 2018, it was Todd that ran the combine along with Mike.
Can you tell us about your relationship with Todd's wife, Amy?
I was in their wedding. I am the godmother of their daughter. At holidays, we would play cards together, do the dishes together, throw darts in the yard. I would stop on occasion to the farm and just visit.
I want to talk now specifically about the summer and the fall of 2018, okay?
Okay.
Do you remember learning that Amy's grandmother was ill and eventually passed away?
Yes.
Did you learn about any other family issues that Amy had going on that were affecting Todd and the kids?
I believe that her uncle was also in the hospital. He had some sort of brain bleed, and she was assisting her mom in taking care of her uncle.
Do you know if that required Amy to be gone from Delaware County at times?
Yes.
Did you have interactions with Todd and the kids and Amy during the summer and the fall of 2018?
Yeah, I would see them on occasion, yes.
Did you have any concerns about Todd and Amy's relationship?
None.
I want to talk now specifically about November 10th, 2018. Do you remember what you were doing that day?
I was babysitting my 2 grandsons.
Did you get a call that day about Amy?
Yes.
Can you tell us what you did after you got that call?
After I got the call, I assigned the babysitting duties to my husband, and I jumped in the car and I went to the hospital.
What did you see when you got to the hospital?
At the hospital, we went into the family room, and there was some friends that were in the family room, along with Todd sitting in a chair. His eyes were red. I could tell he had been probably crying or was upset. And there was, I believe, I'm not exact, but I think that, I mean, there was other people in the room, but I don't know who they were.
Okay, no, that's okay. And if I ever ask a question that you're not sure about, please ask me to ask it again.
Okay.
While you were in the waiting room, did you learn that Amy passed away?
They had come and asked Todd to go back to the emergency room where she was at, and when he came back, they said she had passed away.
At this point in time, what was your understanding of what had happened to Amy?
There was a farm accident at the farm, something with the red shed.
Did you help Todd with the logistics and the arrangements for Amy after that point?
Yes.
Did you help him make the funeral arrangements?
Yes, I went along with her mom and stepdad, and Taylor, I believe, also went along to help, and we made the funeral arrangements in Manchester.
After the funeral arrangements had been made, did you learn that there were concerns that Amy's death was not an accident?
When I was going up to the farm, on, I believe it was the 16th, I had called Todd that I was on the way, and he said that he had gotten a call from Sheriff LeClaire that he wanted him to stop in at the office, and they were gonna get the file basically kind of wrapped up, closed up, and so we could move on. So,
And I don't want you to, I want to make sure I keep asking. So on November 16th, is that when you became aware that there were concerns about Amy's death not being an accident?
yes.
Okay. And so at that point, you learned that the sheriff wanted to see Todd. What did you do?
I picked him up and I drove him to the sheriff's office for this interview to get it wrapped up. I waited in the waiting room.
Do you know how long you were in the waiting room while Todd was with the sheriff?
It was approximately 2 to 3 hours at least.
What happened when you and Todd left the sheriff's office that day?
They had told me they issued us, what do they call them, subpoena, and that they wanted to get Amy's phone from the farm. And so we basically drove back to the farm then with, just in the car with the subpoena or in our hand.
Hey,
Was
good morning,
reading it, I guess.
Sherry.
It could it also have been like a search warrant?
Oh, yes, that's what it was, sorry.
Okay. At that time, did you learn what investigators thought had happened to Amy?
I'm gonna object. This is calling for based upon hearsay.
Well, overruled, the witness can testify as to her understanding.
When I went into the interview room, Agent Turbot had said that we know Todd did this.
So at that point, in your mind, what are you doing? Like, what are your next steps?
I guess I was in shock, number one. Next step, I thought, where are you coming up with this? Because it was a farm accident. And I was trying to think, who do I call? So,
Did you contact
what my
an
mind
attorney
was.
between the sheriff's office and the farm?
say that again?
Did you contact an attorney between leaving the sheriff's office and arriving at the farm?
Yes,
Were you at Todd and Amy's then when the search warrant was executed on the 16th?
yes.
How would you characterize your interactions with law enforcement during that process?
After we had given them the phone, they wanted to see the buildings, and when we were walking to the building, Travis Hemesath turned around and said, "You need to tell your brother."
Sustained.
If you can characterize it
Ooh,
without
uh-oh.
repeating what someone said to you as far as, was it hostile or angry? Was there a lot of back and forth? What do you recall observing and being a part of?
Can you re-ask that again? Sorry.
Yeah. When the search warrant is being executed on the 16th, can you describe for us what was happening? Were officers also talking with you and Todd?
I'm going to object, Your Honor, on hearsay and backdoor hearsay, even if we're cabining it where it's not saying specifically what they said, it's based upon those statements and observations of those statements.
Yeah, I mean, I think that question is probably inviting hearsay, Ms. Nichols-Cook. I'm not sure if maybe you can rephrase.
Let me try, Your Honor. Thank you.
Hearsay and
Would you
backdoor hearsay.
characterize the interactions that you had with investigators as being aggressive towards you?
Same objection, Your Honor.
Overruled.
You can answer.
Yes,
After the search warrant was executed, did you help Todd make any adjustments to the funeral arrangements for Amy?
yes. We spoke with Bob Sabers, and we just plain asked him, do we want to wait on getting the cremation process delayed if there's going to be issues?
I'd like to show the witness Exhibit 310, just the first page. Let me know if it pops up on your screen.
It's not popping up for some reason. Just a second here, counsel.
Your Honor, maybe approach the witness and show her one of our screens.
You certainly can. It's not acting like it's connected at all, so I'm not sure what the issue is.
Oh, I forgot. I need to put it on 1.25. But let me know if it's too
Recognize that
fast.
document?
Yes.
Can you tell us what it is?
It was the letter that was drafted to by Leonard Funeral Home in order to have them delay the cremation.
I object on hearsay on this letter. The letter's not in evidence, and it's signed by Mr. Mullis, so it's hearsay.
Okay. The objection's overruled. The answer will remain in the record. And you had not offered it yet, correct, Ms. Nichols-Cook? All right.
Ms. White, did you help Todd write this letter?
We talked to the funeral home, and the funeral home director is the one that wrote it.
And did you?
I was on
type
the
it up
phone
and
call.
prepare it?
I was on the phone call with the funeral director at the time, yes.
Did you type up this letter?
I don't remember.
Have you seen this letter before today?
Yes,
And is what you have seen today a true and accurate representation of the letter that you helped Todd prepare for the funeral home?
yes.
At this point, we would move we would move page 1 of 310 into evidence.
Mr. Bakke?
With the caveat, we're just talking about page 1. I have no objection on foundation, but I would object on the same hearsay grounds that it's signed by Mr. Mullis.
.310, page 1 is admitted. The objection's overruled.
Thank you, Your Honor. Ms. White, I want to move on a little bit and talk about, you mentioned Bob Sabers earlier. Is he an attorney?
Yes.
Were you involved in hiring counsel or representation for your brother Todd?
I assisted, yes.
Is Mr. Sabers one of those attorneys that you met with and hired?
Yes.
Do you recall when you first hired Mr. Sabers?
After talking to the lawyer on the way back to the farm, we also asked him, you know, it was not the type of law that he had or practiced, so he suggested some names. We're like, who do we talk to? So he suggested some names, and we called Bob. Actually, I called Bob, but
Thank you. Do you recall the date that Todd was arrested for Amy's murder?
February of 2019,
And at that time, did you let Mr. Sabers know about the arrest?
yes. I was at work, and I got a phone call from my brother Mike, and so then I proceeded to call Bob and find out what was going on.
And so at some point, did another attorney become involved in representing Todd on these charges?
Yes.
Do you remember his name?
Jake Firehelm?
And while these attorneys were representing your brother, was Todd in the county jail?
Yes.
And at times, was he also moved to the Buchanan County Jail?
Yes.
What was your role with the attorneys while they were representing Todd?
I was kind of the middleman as far as communications. I was the gopher to find information to get to them.
Were you in communication with Todd while he was in the county jail?
Yes, he would call.
How often would he call you?
Oh, probably at every 2 or 3 days, every day. It just depended on the week.
When you said you were the middleman or the person, does that mean you were asking the attorneys questions?
Yes.
And were you also then providing them information or answers to their questions?
Yes, correct.
Was Todd asking you questions?
Yes.
Were you able to give Todd any answers?
None other than they're working on things, because I didn't want to get into details over the phone.
And why was that?
The phone calls are recorded.
Do you recall Todd writing notes and letters to the attorneys while he was in jail?
Yes.
Would you also then get copies of those from the attorneys?
I would get the originals from the attorney.
I want to show the witness a prior exhibit 233.
Oh, and it came up.
It popped up now.
Thank you. Ms. White, this exhibit has several pages, but looking at the first page, do you recognize it?
Yes, it's one of Todd's letters.
And we can scroll slowly for you.
Hey, Margaret.
Does this appear to be a continuation of Todd's writing?
Yes.
Okay. What about this page?
Yes.
And the next one?
Yes.
And the next one?
Yes.
Okay. And on this one, do you see a date at the top?
Yes, August 29th, 2019.
Based on your recollection, is this before the criminal trial?
Yes, that was in September.
Next page. Is this also Todd's writing and continuation of the prior letter?
Yes.
And same question here.
Yes, continuation.
And we've covered all the pages in that exhibit. So can you tell us a little bit about what types of questions and information Todd was looking for while he was in jail?
Well, he kept asking if we were going to have the scene recreated, if we could possibly get experts on what they were looking for.
I'm going to object on hearsay grounds. Party opponent to himself.
Overruled. You may continue with your answer.
Can you repeat the question, please?
Yeah, I'll ask you another question. Did Todd and you have conversations before he went to jail about, what would happen if he was arrested?
Yes.
And did you get kind of chosen to help, be a voice for him?
Yes.
And so when Todd would communicate with you, either via letter or phone calls, would you take concerns that he had to the attorneys?
Objection leading.
Overruled.
Yes. I would call them and just call them like every day. What's going on? What are we doing?
And did you also send them emails?
Yes.
At any point, did they start sending you updates about the case and what was happening?
They would send phrases along saying we're working on things and just tell me they were working on things. I mean,
What was your understanding of what that meant? We're working on things.
Objection, it's based on hearsay and vague.
Sustained.
What did you think was happening at that time?
Objection calls for speculation.
Asking for her own understanding and to explain the actions that she takes next. It's not asking her to repeat any out-of-court statement for the truth of the matter. It's what she thought was happening.
If you can clarify as to the time period, the witness may answer.
Ms. White, during the time after Todd's arrest, before his trial, when you would have conversations with the attorneys and they told you they were working on things, what did you think was happening?
I'm going to object again on hearsay and speculation.
Overruled.
well, they shared things with me, and in sharing things with me, I would ask them what's being done about materials they had shared with me. If they were working on things, we kept telling them too, it's an accident. What are you finding out? Are you going to recreate this? What are you doing?
Okay. And you said they were sharing things with you. What types of things were you getting?
I got just about everything. Medical examiner reports, her medical records. I got police reports. I got the Celebrite information. That's what I can recall right now.
And I know earlier I briefly asked about your work history, but to clarify, that didn't include any investigative training or experience?
No,
Any cell phone, Cellbrite
no,
type of experience? Do you remember talking with anyone else besides the attorneys directly during this process, during this time period of leading up to trial that worked with the attorneys?
yes.
Who'd
I
that
talked
be?
to the secretary for Jake Firehelm, and the two of us collaborated on a lot of the issues that we had in front of us. I would do things on the Celebrite. I would work up reports and figure out how to get everything in line, and then I would call Christy and ask her if she saw the same thing, and told her basically, she's like, how did you get that? So then I went through the steps on pulling up the
Right,
Celebrite
Margaret.
information and told her how to basically connect everything together. And then she would let me know that she was going to show this to the attorney, Jake, and share it with Bob.
Did you ask her if they had an expert to review the
I
digital?
told her, I asked her, I said, we need somebody to look at all this. We need a computer guy to do this. But when she asked, well, how did you get that report? I would explain to her and tell her in detail how I come up with the report I had.
I'm sorry, I didn't hear your objection.
Hearsay. Thank you.
Overruled. The answer will remain in the record.
To your knowledge, as the person who was representing your family with these attorneys, did either attorney ever consult or hire an expert to review the evidence that you were getting copies of?
We asked several times, but I was not informed anybody was hired, and I kept inquiring, who do we have?
In the weeks leading up to the trial, did the attorneys ask you or the family for any information or assistance?
Yes, we provided them with drone footage of the farm a few days before the trial. We provided them with pictures of the barns, the area where Todd was working at. We provided, actually, Bob had emailed me asking me if I would draft some questions about,
Objection, hearsay.
Sustained.
It's okay. So was this the first time they'd asked you to do things to help with their
not the
representation?
first time. I offered, what can we do? How can we help? What do we need to do to help in the accident, to get information out to show?
And then did you write questions for witnesses
Yes.
and provide those to the attorneys?
Yes, since the attorneys didn't have a background on some of the people on the deposition list, they just said, can you give us a little background on these people and maybe draft some questions as to what to ask them in the deposition?
Had you ever hired and worked with attorneys before?
Hired, I've got a tax attorney. Other than that, through my work at the city, we had a city attorney. At my job now, we have attorneys there. I don't hire them, but I
For a
work with
personal
them.
matter, for a family matter like this?
Not for a family matter like this, no.
Did you have concerns that you brought up to the attorneys before trial?
I kept asking them, are you going to talk to Todd about what's going on? Are you in communications with him? Does he have everything he needs as far as what's going to be presented? Several times we talked.
What was your impression after phone calls with Todd about whether he had information about what the attorneys were doing?
I'm going to object that this is based on hearsay or backdoor hearsay.
Sustained.
I need just a moment, Your Honor.
Sure.
Would Todd communicate frustration to you?
Yes.
Same objection.
I'm not asking for a statement. It can't be hearsay if it's not a statement. So I would,
Overruled. The
Thank
answer will
you.
remain in the record.
Oof,
were you
she's
able
like,
to discern why
"Rawr."
Todd was frustrated?
Yes, he would state that the attorneys would, sorry,
Objection, hearsay.
I didn't hear that, sorry.
Without telling me what Todd would say, could you discern, what it is you needed to do next?
Objection, this is backdoor hearsay.
I'm asking for her actions, what she did next. So it's not truth of what Todd said, it's the effect it had on her and what she did.
The objection's overruled. Ms. White, just be careful to talk about what your actions were and not what statements were made to you, okay?
Okay.
All right, you may proceed.
The actions that were taken was to get a hold of the attorneys and see what was going on.
So you were asking more questions?
Yes,
And would you also send them emails?
yes.
Did they ever ask you to review pleadings before they filed them?
Yes, they would send me drafts, and I would help them with some grammar and punctuation, that type thing, yes.
Prior to trial, did you ever learn that the attorneys were not going to pursue an accident theory?
No,
Did you attend the criminal trial?
yes, every day.
Were you present in the courtroom during the defense opening statement?
Objection, relevance.
Overruled.
You can answer.
So, yes, I was.
What was your reaction to the opening statement?
Objection, relevance.
Overruled.
Shock and dismay, wondering where it came from.
During the trial, did you attempt to speak with the attorneys?
Yes,
Did you ask them questions?
yes,
Did that include wanting to know what the plan was for the trial?
yes,
If you had been informed before the beginning of the trial that counsel was going to concede Amy's death was a homicide, would you have done anything?
I'm going to object as calls for speculation and relevance as to her thoughts of what the trial strategy was.
Sustained.
Ms. White, if you had been informed or made aware about counsel's opening statement, would you have taken any action?
Yes.
What would you have done?
Objection, this is relevance into what her actions or statements or conduct would have been in response to trial counsel's trial strategy is not relevant.
Right, sustained.
If you had known, would you have gotten new counsel for your brother?
Same objection.
Sustained.
Were you ever consulted about conceding homicide?
Same objection.
Overruled.
No.
To your knowledge, was Todd ever consulted?
Objection, there's no foundation that she was aware of every conversation between trial counsel and relevance, even if there was.
Overruled.
I was not aware of any communications on that, no.
Do you recall talking with Todd after he testified at his trial?
Yes, he called us on the way home, I believe.
Was he upset?
Yes,
Were you upset?
correct.
At that time, in 2019, did you think Amy's death was an accident?
Say that one more time.
At the time of the trial in 2019, did you think Amy's death was an accident?
Yes.
Have you learned anything that's ever changed
No.
your mind? Did you meet with the attorneys after the trial?
Yes. We met with Jake. Bob, we didn't meet with him, I don't believe.
Did you ever learn that Todd now thought Amy's death was a homicide?
Objection based on hearsay or backdoor hearsay. If she learned that information, it's based on statements that were made to her. So even if it's cabined in such a way that it's not reflecting the statement, it is based upon the information that was learned that is hearsay.
Sustained.
Ms. White, has your brother always maintained his innocence to you?
Yes.
And then I think I just have maybe one thing I forgot to ask you in the beginning. Do you recognize this glass fixture that I'm holding up?
Yes.
Can you tell me what it is?
It's a light cover that they use in the hog buildings to go over the light bulbs.
Did you provide this to the attorneys?
Yes.
The current attorneys for Mr. Mullis?
Yes, I did.
And did it come from the hog barn at the Mullis farm?
Correct.
Your Honor, at this point, we would move to move Exhibit 275 in.
Any objection?
Not on foundation, just on relevance.
275 is admitted.
And, Your Honor, I know it's noon, and I need to queue up perhaps my last exhibit. If the court could give me a minute, or if the court wants us to come back after lunch, I'm fine either way.
We can keep going, I think, if it makes sense to finish up your direct.
Ms. White, do you remember we were talking earlier about talking with Todd after he testified at his trial, if that would have been September 22nd, 2019?
Yes.
And I know you mentioned earlier that the calls, when Todd would call you from the jail, they would be recorded. So do you remember him expressing frustration about the questions he was asked on cross-examination?
I'm going to object on hearsay.
So far, as long as you're not responding to specific statements that were made, the objection will be overruled. You can answer.
Was he expressing frustration?
Yes.
And Your Honor, I would like to play this call that we're talking about. I believe it's a prior consistent statement of Mr. Mullis, and so it would satisfy an exception to any hearsay objection to aid Ms. White in her testimony.
And I anticipate I know which jail call this is, Your Honor, and I would object that this is not a prior consistent statement that was made under oath at a prior court proceeding. This is simply a jail call between Mr. Mullis and his family member. It falls directly within hearsay. Mr. Mullis, of course, could have testified about his own recollections, but he can't testify through another witness.
Which exhibit is this?
It's in the jail calls, I think 375, and there's 686 jail calls in there by my count, so.
Ms. Nichols-Cook, I guess, as far as the issue of it being an exception or not, any further record you wish to make on that?
Yes, Your Honor, I think that there was a lot of cross questions about Todd's testimony at trial and whether he conceded it was a homicide in his testimony. And this phone call comes directly after that, in which Mr. Mullis explains that he still thinks it's an accident, but he didn't know how else to answer that question on cross-examination. And it is consistent with all of his prior statements to law enforcement that her death or her injuries were the result of an accident. And that is what he continued to tell his family and his attorneys throughout the process.
Okay, again, though, if this is Mr. Mullis's statement that you're using, correct, not this witness's?
Yes.
All right. So we'd still have a hearsay problem then, it sounds like.
I do think it could also fall under the residual hearsay exception.
And just for purposes of the record, there has been no notice of residual hearsay exception being intended to be used at this trial.
So at this point, I'm not thinking that this would be admissible.
Okay, I can move on, Your Honor, and
right.
ask a final question. Ms. White, have you continued to support your brother throughout his legal proceedings?
Yes.
No further questions.
Okay, Ms. White, you may step down for now.
Your Honor, I think I can keep this very brief if that's acceptable.
Absolutely, certainly. You may go ahead with your cross.
Thank you, Your Honor. And I guess good afternoon, Ms. White.
Good afternoon.
It's just so we're all clear, you are Todd's sister, right?
Yes.
And it's fair to say you love your brother,
Yes.
you care very deeply about him,
Yes.
and that you did everything you could in your power to assist him with his defense.
To keep communications between him and the lawyers and just to keep the ball rolling, yes.
And you still believe in his innocence and want to see him be successful in this action. Is that fair?
He is innocent.
You were asked a couple questions about helping review pleadings. Do you remember that?
Yes.
Would an example of that be, so there was a bond issue, I believe. Were you asked to review specifics about how much land Todd owned, for example?
I had to give background on that, yes.
So that would be an example of specifics you were providing to the attorneys to put into the pleadings?
Just a small portion.
You were also aware, or are you aware generally, that if an attorney talks to you, if you're not the client, that it would waive attorney-client privilege?
I was not aware of that.
Are you aware of it now, generally?
I did not know that, no. I believe Todd had permission with the attorneys or told the attorneys that they should be talking to me as well so that I could be his middleman on the outside, I guess you'd say, to help with communications and make sure that the process was functioning and moving along.
Thank you. I have no further questions. Thank you.
Any redirect?
One question, Your Honor. Ms. White, did the attorneys ever give you any information about what their strategy was going to be to pass on to the family or to Mr. Mullis?
Never.
No further questions.
Any recross?
No, Your Honor, and just for the record, we would release Ms. White from our subpoena as well. And thank you.
Okay, thank you.
Okay, thank you. Now you may step down, Ms. White.
Oh,
Thank you. All right, let's go ahead and take our lunch break at this time. I think, council, based on our earlier discussion this morning, Ms. White may be our last in-person witness. Is that correct, at least from the applicant's side?
Yes, Your Honor, that's my understanding.
Okay. I know that we have several witnesses that will be presented through their deposition testimony or by stipulation or other agreement. And the state may need an opportunity to confer before there's any final plan as far as presentation of in-person testimony. I don't know, counsel, were you in a position to commit to that at this time?
Yes, Your Honor, I can commit. As the court and both parties know, we have been attempting to ask our questions during cross-examinations to streamline matters, so we will have no additional witnesses to call at this time, just the depositions and the evidence that has been presented.
Okay. So I guess more for the benefit of those who are here observing, there would not be any additional in-person testimony. The remaining matters that need to be addressed between the parties and the court would consist of arguments regarding some remaining evidentiary issues, and then, I guess, discussions and clarifications regarding the agreements, regarding the remaining witnesses that we have to talk about. I know that council is continuing to work on some agreements as far as how that testimony would come in specifically for the court's consideration. So we'll certainly pick up with that after lunch. And then once we've concluded that, I'll provide both parties with an opportunity for some limited oral closing argument. And both parties will then also have an opportunity to submit brief written legal briefs to the court to identify any legal authority that they believe would be particularly helpful. So we'll discuss deadlines for that as well when we come back this afternoon. I anticipate that our arguments and our discussion regarding the evidentiary issues will take some time. I would propose that both parties have up to 15 minutes for any oral closing argument that they wish this afternoon. I'll also provide the applicant an additional 5 minutes for a rebuttal closing since it is the applicant's burden. So we'll plan on concluding with that at the very end of everything else that we need to do this afternoon. Anything of a housekeeping nature that we should address then before we break for lunch on behalf of the applicant?
Nothing, Your Honor.
Anything on behalf of the state?
No, Your Honor.
Okay, let's plan on picking back up then at 1:30. All right, I'll see you back here then. Thank you.
Okay, so it looks like they're ready to wrap things up, y'all. Looks like they're ready to wrap things up. Oh my goodness. The cool thing is this was yesterday, so we can zoom, 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 and a boom, boom. Y'all gotta say it in the chat now. Before I hit play, you have got to say what follows. Zoom, 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 and a boom, boom. You better say it or I won't click the play button. Zoom, 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 and a boom, boom. Shake your rump. Just shake your rump. Yeah. Margaret and Michelle, you girls. Yes, yes, yes. Just shake your rump. Do the Humpty Hump. Looks like he super glued his hair back in place. I'm so mean. So mean. Ay, ay, ay. Da, 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 da. There she is with her cute glasses again. I want to steal her glasses. Hell, just shake your rump. Hey,
Okay,
Steph.
we'll go back on the record.
Hi, Steph. Popped in, popping back out because I haven't watched a single video about this case, but I'll be back. Good to see you, Steph.
Just before lunch, both parties, well, I guess both parties rested in terms of calling live witnesses. However, I think
Okay, love you.
at least the
Bye.
applicant has additional witnesses to identify by deposition. Is that correct, counsel?
Yes, Your Honor, I believe they're on the exhibit list, and the court would like, we can go through them.
Yes, let's do that, please.
Love you too, Steph. Margaret says hi.
Exhibit
Bye.
204, Turbot 2019 deposition.
Okay.
They believe that both of these are already submitted.
Yeah, we did some of them maybe at the beginning.
Yes.
Yeah. There's 258, Hemisath 2019 deposition.
All right, you show both 204 and 258 as having been previously admitted.
Okay.
I want to skip through this boring stuff.
301,
That was previously admitted.
I think the 323 would be one the state would want to talk about.
Yes, I agree with that.
Yes. And I do not show 325. Okay. All right, thank you.
Through 337 are also depositions, was Ms. 7,
Submitted.
Been per-
38.
Yes, I show that those have all been admitted. 52 is it?
And I would just note for clarity of the record that this was a discovery deposition. I believe it was taken before the state even had the benefit of receiving discovery. Not that there was any problem with that, given the timing of when it occurred, that was to be expected. However, given the timing, the fact that it was a discovery deposition, it, in the state's opinion, does not make sense to admit it. And as Mr. Firehelm testified in his testimony here on Friday, confirmed that he did not have his own file when he had that deposition. I believe the parties were able to adequately impeach or refresh his recollection based on his deposition, so his testimony should remain as what he gave in court.
Any further argument in support of your request to admit 323, Ms. Nichols-Cook?
Your Honor, I think our goal here is a complete record for the court to have, and it is additional sworn testimony that Mr. Firehelm gave in addition to the affidavit that he signed and was shown. And I believe the deposition will assist the court in evaluating his credibility and his testimony this week.
323 will be admitted.
Thank you, Your Honor. Your Honor, I believe the parties have an agreement as to Exhibit 371. This is a DCI Google search comparison chart created by Roman Gamble, and we would seek to admit it.
I show 371 as having been previously admitted.
I believe it was referred to during Sheriff Hemeseth's testimony. However, in any event, we have no objection to it. I believe he laid sufficient foundation for that.
Okay, if it wasn't previously admitted, it will be at this point.
And Your Honor, I know in our last witness, we talked about 375, the jail call records. We would still move to admit for the court's consideration just the September 22nd, 2019 phone call recording that is within that exhibit. It might be more of an offer of proof because of the objections that were made to its admission, and ask that it be admitted as an offer of proof.
375 was the number? Okay.
There's many phone call recordings within that electronic exhibit, and we're just specifically asking for the September 22nd, 2019 call. I apologize, I don't have a better way of identifying it for you.
Okay. I guess to the extent it's being, or the court's being asked to consider it as an offer of proof, any additional record you wish to make on that point, Mr. Bakke?
Yes, Your Honor. The state objects to the admission of the jail call for the reasons already stated and addressed in the record, hearsay, among others. I guess I'm confused what the purpose of admitting it for an offer of proof would be at this point when no additional witness testimony is expected. So we would object to its admission.
Well, the court will consider it as an offer of proof, just so that it is part of the record for purposes of any further proceedings in this matter.
Thank you, Your Honor.
Are you going to refile that?
Just that once.
All right. And I know we have some other exhibits to talk about. Ms. Nichols-Cook, does that address all of the additional witness testimony that was coming in on behalf of the applicant through deposition?
Yes, Your Honor, there's one topic regarding Mr. Saber's deposition. The exhibits used in that deposition are separate exhibits on this court's trial exhibit list. And I know the state had some objections to some of those. And I don't know if the court would like me to identify which ones I believe are referenced in Saber's deposition for the record, or what's the best way to do that?
That's probably the best way to do it if they're not all contained within the same exhibit. So Mr. Saber's deposition is which number?
320, what? 323? 325.
Okay. And then the exhibits that go with Mr. Saber's deposition.
That would start at 219, Your Honor.
Okay.
220. 223. Yes, 223, I'm sorry. 234. 235. 236. 237. 238. 239. 240. Actually, through 246. And then 247 through 252. And 278. I believe those are all the ones referenced in that deposition.
Okay. So some of these are on my list of previously referenced exhibits that were problematic. I don't know if those are the ones that you're referring to, or if it is some of the newly identified exhibits that are troublesome, I guess. Mr. Bakke or Mr. Duden. Did one of the two of you wish to identify which exhibits are objected to, or do you need a minute to confer?
Your Honor, our objection is only to what we had previously expressed during our pretrial motions as well. That we would ask that those exhibits and depositions be considered for their weight because they do contain hearsay, rather than more so for the truth of matter asserted. But we would also note that 252 has been previously admitted as a part of 233. I believe it's the later pages of 233 are in the middle section. Either way, for clarity of the record, we don't have an issue because it's cumulative and the court's already admitted it. And subject to the state's objection on the use of hearsay testimony in those exhibits, we don't have any objection to those being included here.
All right, so 325, the deposition of Bob Savers was previously admitted. And then as I understand it, 219, 220, 223, 234, 235, 236, 237, 238, 239, 240 through 246, 247 through 252, and 278 will also be admitted, subject to any prior orders of the court limiting those exhibits. And it's possible that at least one of those was already previously admitted, I guess.
Yes.
Okay, all right. Okay,
Okay, thank you, Your Honor. I think after that, it takes us into exhibits related to expert testimony. I believe those would be Exhibit 274, Dr. Bowley's report, 279, Dr. Weck's report, 285, Dr. Nye's report, 276, the portion that is Dr. Hammer's report, 281, Mr. Safaric's report, that we would move to admit those. I understand the state has raised a concern that they could be improperly used to bolster or vouch the experts who did testify. However, expert witnesses are allowed to rely on other information and data under Rule 703. This is something they testify they normally do in the course of offering an expert opinion. The data in 703 is not hearsay. It's also, this is a bench trial again. The court can afford their proper weight to these exhibits. And it goes to more than just, what Dr. Hammers and Dr. Nye testified to. It shows the prejudice of counsel's errors at the trial and provides that context for the court and the record of what is being discussed and reviewed. So even the reports don't have to be admitted for the truth of what they're saying, but it's for their use under 703.
response on behalf of the state?
Yes, Your Honor. As the court knows, we have always objected to the inclusion of, especially of the reports and information present in this case from non-testifying experts. Those reports are being offered, in our opinion, either for a vouching purpose or for the truth of the matter asserted, and therefore our hearsay that would be impermissible for inclusion of the record here. But for the use of those reports, subject to the state's objection, we have no issue with the court taking it under advisement if they would like to evaluate it, given that prior discussions have occurred for instance, of Dr. Nye's first report as a mere report of vouching to the credibility determinations of Dr. Bowley or Bowley, who did not testify here. In subject to our hearsay objection, I don't think there's any way around considering them for their truth value. So we would ask that they remain to be excluded in subject to the court's determination, but no further arguments necessary on these because we've maintained our objections from the very beginning and before we came to trial.
The expert reports will be admitted, subject to those objections, and my final order will clarify, I guess, to what extent, if at all, the court considers the opinions of the experts. Well, and let me clarify. I'm going to defer my determination of admission of the expert reports, and my final order will indicate to you what is admitted, because I do need to review those in more detail to determine if I can separate out any portion of the report that should not be admitted. And primarily that deals with the information from BOLI. Under the case law and under the rule, it really is the BOLI report that is problematic. I don't think that there is any way of interpreting the inclusion of BOLI's report in Dr. Nye's report, for example, as anything other than a conduit for getting BOLI's opinion in when it otherwise wouldn't come in. And that is not permissible under our rules and under our case law. And so I think it can be excised in all likelihood without damaging or taking away that portion of the work that Dr. Nye did, certainly from her second report. But I will clarify for the parties in a written ruling that in fact that is what I have done. And so with regard to the experts, that will be the plan that we follow with those reports.
Can I get clarity on just which exhibit numbers? I was a little slow in writing them down. I apologize.
Sure. So BOLI, I believe, is, her separate report is identified as 274. Let me just double check my numbers here. Yeah, 274. WECT is 279. Nye is 285. Hammers is 276. And Safaric is 281.
And then, Your Honor, my friends in appeals would be remiss if I didn't ask to do this. But regarding the jail call that was submitted for the offer of proof, if I can read the name of that file into the record, just so everyone is clear going forward what we were talking about, if there's no objection.
Go ahead.
My records show it is called 687-308-34 underscore 392-804 underscore 09-22-2019 underscore 08-12-58. And there's more to it, but I believe that should be sufficient to identify it.
Thank you for that. I'm sure that'll be helpful for the court too in locating the particular call to the extent I would need to. So. Okay. Ms. Nichols-Cook, anything else that you wish to address with regard to exhibits?
Your Honor, I know that we all agree the underlying record is a part of this proceeding. I think we've realized we did not file the motion for new trial sentencing transcript from September 4th, 2020. And we would like that to be a part, of course, of the record. And if there's no objection, we can upload that today. And it would be like 978, I think.
Any objection to that, counsel?
No, Your Honor, it's already part of the record. If it's easier to have it filed here, no objection.
it doesn't make any difference to me. I mean, if you wish to have it marked as a separate exhibit in this file, that's fine. But certainly by statute, the underlying case file would be considered part of this record. So it's up to you, counsel, if you wish to have it marked separately.
I think so, Your Honor.
Okay?
Just for clarity, what's 977?
An email that the fire home was shown?
This portion of trial stuff is always so boring.
So 978 was the number you said you would use for that? Okay, that will be
Do you
admitted.
mind if I skip through
Your Honor,
it?
the next thing on my list is to address the photographs that were submitted as exhibits. Obviously, we did not show or utilize every photograph that had been proposed. And I think that we can identify a handful of them that we know were shown to witnesses that we believe should be a part of the record, but we also don't oppose the admission of additional photographs or the group exhibit in its entirety, if that's what the court would like.
Is having been admitted, or the witness didn't talk specifically about also 600 through 655, which I believe are all photos. And again, I know,
Your Honor, we just received the signed one, so maybe if we circle back to this in 5 minutes.
certainly
sure we can
that works just fine. We'll do that.
Authenticate and lay the foundation for those exhibits. We would ask to be allowed to move those in upon receipt of those declarations.
Any objection to that on behalf of the state?
We don't know what the full declarations look like, so we would ask that the court allow us to defer. We don't anticipate there being any issue with the declarations, but some of the information was still kind of outstanding or highlighted within the judicial branch's declaration page.
Okay, I guess on that issue, then we technically probably just need to leave the record open to receive those.
Your Honor, we just received the signed one, so maybe if we circle back to this in 5 minutes.
Certainly,
sure we can
that works just fine. We'll do that.
Your Honor, I just had a couple left on my list to make a formal record on, that the applicant does seek to admit the affidavit of Carrie Piersbacher as identified as Exhibit 215, the affidavit of Jake Firehelm in 224, the affidavit of Donald Pottebaum in 379, as well as the transcript of the November 10th, 2018 911 call, identified as Exhibit 294.
And so I'm fine calling them court exhibits.
Also require a higher security level. Your Honor, I'm sorry, there was one more related to the jury discussion. It's Exhibit 397. It's a U.S. Census Bureau report.
Issues on behalf of the state. I have not necessarily cross-referenced my list of notes as far as outstanding exhibit issues. Maybe for fear we'll discover more, but I think we've hit certainly the major things as far as exhibit reports.
I guess the only clarification, just to make sure that your list matches ours, that it's all except Exhibit E has been admitted. Then I believe we have covered everything as far as my notes reflected.
Have the parties compared notes as far as which exhibits of the applicants they think have been admitted?
No.
But we can do so when we verify our final list and information. We can either do it now, Your Honor, or we can do it at the time we do the protected information, but probably for purposes of closing, it might be easier just to do our closings and then verify that information after the fact, given the numerical changes and things like that.
I mean, it seems to me like it would be prudent just to be 100% certain that everybody's on the same page as far as what exhibits have been admitted before we leave here. I understand it's tedious and not super exciting to sit here and do that on the record, so we definitely don't need to do that, but maybe before you leave here today. And also, just to make sure that my list appears to match as well, would be a good idea, because obviously there are a lot of exhibits in this case. But with that said, if you think that we have addressed all of the kind of lingering cleanup issues that we needed to, if you would like maybe a short break before closings, we could do that and then come back and wrap up.
Yes. Your Honor, the last thing I had to put on the record was that the court's order regarding summary judgment, any motion to reconsider or enlarge would be due this Friday, and the applicant would just request an extension to consider that.
The state's position?
If I recall correctly, the summary order regarding the court's positions on summary judgment said a longer order was forthcoming. Should the court be open to it as well as applicants' counsel, I believe that the state would just request the opportunity for that deadline to toll until after the court's full ruling speaks to it, so that the actual questions and issues can be responded to specifically in addressing the court's specific decisions.
Yeah. I kind of like that idea. That maybe seems to me to be the most efficient use of everybody's time. Counsel for the applicant, does that
No
work for you
objection
guys?
to that plan, Your Honor.
Okay. So we'll plan on that approach, and just to have less dates to keep track of, maybe, if nothing else. So, okay. All right.
And then one last matter, I believe the court indicated brief deadlines would be addressed. Do you want to do that now or at the end?
We can talk about that now. Do either of you have a request as far as how long you would like to submit final legal authority to the court? I think I mentioned earlier, I'm not contemplating anything extensive. And really, unless you're telling me you are wanting something more substantial, I'm contemplating a one-shot 5-page limit focusing on legal authority that you believe is on point and controlling, and any particular testimony or evidence from the depositions that wasn't on the record these last few days, because I do have extensive notes from the testimony that we've been listening to. So if there's something that you want to draw my attention to from those depositions, obviously I will read them, but if there's something that you want to highlight, you could do that within that 5-page limit. Yeah, go ahead.
It's my understanding from what the court indicated previously that the court would consider the legal briefing on these issues that we already laid out in our summary.
Absolutely, right, which is part of my rationale in suggesting a very limited final brief. Both parties have spent a significant amount of time already briefing the legal issues in this matter. All of that is in the court file. I have access to it, I've reviewed it, familiar with it, and so I don't know that rehashing all of it again is useful for anybody or good use of your time at this point. So certainly to highlight the most critical pieces, now that you know how the evidence has come in, is fine. But to go much further than that, I don't think is particularly helpful. So,
Your Honor, at this point, I think my proposal, unfortunately, would be to ask for 30 days, in part because part of our team is out of the country later this month, and I just to make sure that we could get all of our thoughts together and complete that. I know 5 pages isn't that much, but
April 4th is a Friday. Otherwise, March 31st would be exactly 4 weeks from today.
I think we could probably.
Your Honor, there is a major conference that I think a number of people on applicant side are attending, that the first day of which is April 4th, and I have some professional responsibilities at that conference. I can't move, unfortunately. I don't know if it'd be possible to make this do the 8th instead.
The 8th of April?
Yes.
Yeah, okay. Does that date work for the state?
Is the court seeking simultaneously filed?
Yes, yep, just a one.
Yes, I feel that. Yes, the deadline works wonderfully.
Okay, so April 8, 2025 by 4:30 PM. Okay, if we plan on coming back at 3 o'clock for final arguments, 15 minutes, and a final 5-minute rebuttal?
Thank you, Ron.
Okay, I'll see you then. Okay, we'll go back on the record.
All right, we zoomed through. Now we're going to do the closings.
Okay, we'll go back on the record. Ms. Thompson, you ready to proceed?
Your Honor, Todd Mullis has spoken the truth in this case from day one. He said this was an accident. He asked his attorneys to investigate it as an accident. He gave multiple consistent interviews. He testified at trial. He testified at child guardianship proceedings that are part of the record below from his motion for a new trial. He filed this PCR, a verified PCR. He provided affidavits. His belief has been consistent and has never wavered that this is an accident, that he was in no way involved, and that he wanted his counsel to pursue that issue for him. That's different from other witnesses who testified at this proceeding and whose stories have changed over time. There's nothing that Todd Mullis could have said to this court that he hasn't said before. And that's why this post-conviction hearing has been about all of the evidence that should have been presented at trial to support what he's been saying all along. The court has pointed out that this is an evidentiary hearing, that all of the evidence this court is going to consider is not evidence this court heard in court during the last 6 days. Because as we just went through, the court will have depositions, the court will have documentary evidence, the court will have other evidence from the underlying record that wasn't part of what the court heard, specifically in testimony and at this hearing. But all of that together demonstrates that Todd Mullis's trial was fundamentally unfair, that the system broke down, that he did not receive the fair trial that he deserves. And that is the outcome that Mr. Mullis is asking this court to assist with now. This court really can't think about what Mr. Mullis's claims mean without thinking about what it is that actually happened at his trial. What happened at his trial was that everyone, his own counsel, the state, told this jury that Ms. Mullis's death was a murder. His own counsel agreed in opening statements that Ms. Mullis was murdered, and that belief was allowed to be presented to the jury with zero adversarial testing. I mean, this was the quote-unquote strategy that his counsel pursued at trial. Their strategy was, we're going to concede it's a murder. That's a strategy they reached on the fly, which we'll talk about in a second. And as Mr. Firehelm told this court when he testified here, Todd's going to explain it. Todd will explain all of the evidence, and that is the way that they provided counsel to him through this trial. Their strategy was Todd is going to explain the text messages. Todd is going to explain whether he knew about Ms. Mullis's affair with Mr. Frazier. Todd is going to explain the Google searches. Todd is going to explain the state of his marriage. Todd is going to explain what was happening in this argument between his wife and his mother. Todd's going to explain these hearsay statements from these witnesses. Todd is going to explain without any notice or understanding that he even needed to prepare to think about or testify about this 911 call and what he said and who was there and what he was thinking when he was frantically providing aid to his wife as she was dying. Todd's going to explain the state's circumstantial evidence that is meant to show that he was guilty. And that in effect became a trial where counsel is telling the jury, even though I told you in opening statements that Todd was wrong, believe him that he's not guilty. That is not a reasonable strategy. It's simply not a reasonable strategy, and it and all of the errors that combined cumulatively to deny him a fair trial, denied him a fair trial. There are two Sixth Amendment claims that Mr. Mullis has in this case, and they're different. We talked about these at summary judgment, but I want to talk briefly about them now. One is the Sixth Amendment claim that Todd has the right to be the master of his own defense, and we spent a lot of time on that claim at this hearing, hearing from various witnesses. And I know the court has the law on this that we provided at summary judgment. The law is that Mr. Mullis has to explicitly consent in opening statements, or has to explicitly consent to his counsel conceding his guilt in the trial. He has to explicitly consent if that's the strategy. And from all of the testimony the court heard, from Mr. Firehelm, from Mr. Savers' deposition that the court will read, from all of Todd's letters and his testimony at the child guardianship proceedings that are in the record, that simply never happened. This resulted in a situation where his trial counsel conceded his guilt because he told the jury that Amy Mullis was murdered in a situation where the lawyers were going to provide no evidence to establish that that was not Todd Mullis. The evidence is undisputed that Todd Mullis didn't know his counsel was going to do that. The court has Mr. Sabers' deposition, who testified at a deposition, and the court can review this, that he was surprised at opening statements. He was surprised to hear that that was the position the defense was going to take, that Mr. Mullis was surprised. The court has all of his letters. The court has heard from Lynn White. The court will be able to review Todd's testimony in these child custody proceedings. Todd said he never gave counsel permission to do that. All of his letters support that that's not what he understood the strategy was going to be. Mr. Sabers didn't know that was going to be the strategy. That happened without his permission. And we explained already why that's important, because if that happened without his permission, then this isn't a matter of prejudice. It's not a matter of establishing what the outcome would have been if counsel followed a different strategy. That is just a Sixth Amendment violation, period, that really ends the analysis. And on that basis alone, Mr. Mullis receives a new trial. But that's not the only aspect of Sixth Amendment. That's not the only aspect of a Sixth Amendment violation that is present here. We have a more typical ineffective assistance of counsel claim too. And this is very important because in this case, there is no reason, and the court heard no reason from Mr. Firehelm, there is no reason in Mr. Sabers' deposition to explain why it would have been reasonable for trial counsel not to investigate and present evidence that corroborated everything that Mr. Mullis testified to at trial. To investigate and present evidence about medicine, about the electronic evidence, about these Google searches that we've been talking about text messages, about the cameras. There is no reasonable strategy that would have allowed counsel to not pursue any of this evidence, and instead to pursue what they did at trial, which is to concede this was a murder and to let Todd explain himself unaided to the jury. What's important about this, and what we want to make sure the court understands, is that even though in this evidentiary hearing, the applicant has spent a lot of time presenting evidence to the court and proving to the court that Mr. Mullis didn't agree with counsel's strategy, even if Todd Mullis never wrote a single letter to his lawyer, even if he was maybe a person with a little less understanding about the way that biomechanics work, his instincts about what might be true. Even if we had none of these letters, even if we didn't have the vast record we have here that Mr. Mullis was asking about these issues, that he wanted this to be investigated, that he was seeking investigation, that he consistently and unwaveringly believed that his wife's death was an accident, even if none of that was true, and Todd Mullis had just said to his lawyers, give me the best defense you can, I don't know what happened, but do your best. If that's all he ever said, counsel would have still been ineffective. It is not Todd Mullis' job to have told counsel what the right strategy was here. As it so happens, he did. But even if he didn't, it doesn't matter, because there's no reason not to investigate these issues. This is not dependent on what Todd Mullis agreed to or not. It is ineffective for counsel to have chosen the path that they chose, and that is because they chose it without a reasonable investigation. We cited law to the court in our summary judgment briefings, and we will cite more law. The United States versus Hinton, the United States Supreme Court has said that it is ineffective for counsel not to understand science and not to get experts in a case where expertise is required. And Your Honor, this is such a case. This was clearly a medical case. Mr. Firehelm told you, I relied on my own understanding about this. You know, I was first chair, I made these decisions. I relied on my own understanding to decide that there wasn't anything I needed to pursue there. Under Hinton, under the other law that we've cited to the court and that we will cite, that's ineffective. The state may point out when it speaks to the court that in his deposition, Mr. Sabers did describe, as the second chair, as the person who was not making decisions in this case, some of the things that he tried to do, because he did try to do more than Mr. Firehelm did. For instance, he himself went to the shed. He looked at these augers, and he talked about that in his deposition. He also read the case materials, like Mr. Firehelm did. But there's no evidence that Mr. Sabers discussed these issues with Mr. Firehelm other than telling him that he visited the shed and looked at these augers. And there's no evidence that Mr. Firehelm did anything that Mr. Sabers asked him to do. The state's own exhibits show this, that there is a email from Mr. Sabers to Mr. Firehelm where they discuss we probably should get an expert. I mean, they knew that Todd was asking them to do that. They agreed they probably should get an expert, and that just didn't happen here. They never provided case materials to an expert, either a pathologist or a biomechanical expert, who could explain to them that there was a defense here, a reasonable defense that they should have followed. They just didn't do that. And Mr. Sabers, doing his best to look at a couple of things, to give advice to Mr. Firehelm that he never followed, that's not a strategy, that's not a decision, that's failing to do what you know you should do. And there's no reason that the state is going to be able to articulate for not following the only reasonable strategy here. That leaves us with the question of what this trial would have been, the prejudice issue of Strickland, if Todd Mullis hadn't been standing alone at his trial without any of the assistance that his counsel was supposed to provide him. If his lawyer wasn't just saying, trust Todd, what would the jury have heard? And at the end of this hearing, especially hearing the evidence the court's heard here in court, considering the other materials as well, the court knows the answer to that. The court knows that if this had been a fair trial with effective assistance, this jury would have heard that this was not a murder. And it would have heard that from sources that are far more credible than the state's witness who testified at trial without any cross-examination, save one question, that this was a murder. This was a medical case. And the court heard extensively, and I know we spent a lot of the court's time, making sure that the court could hear the opinions of Dr. Cruz, the opinions of Dr. Hammers, the opinions of Dr. Nye, to decide what the true state of the medicine is. And based on that testimony, there's really no question what the state of the medicine is. This is not a murder. This is not a homicide. This is an accident. Dr. Hammers was able to talk about that from a pathology perspective and explain why, despite there being unopposed testimony offered at trial that Ms. Mullis had defensive wounds, that there was nothing about the state of her body or this autopsy that indicated that she was the victim of a homicide, but that this was an accident from a pathology perspective. The court knows that Dr. Cruz said that she couldn't really figure out how this happened. She just couldn't see any reason that it was an accident, and that is essentially why she determined this was a murder. After 2 to 3 hours of doing this autopsy with other autopsies, she came to that decision, she stuck with it, and she made that decision without the benefit of any biomechanical testimony, any biomechanical advice or assistance. The court has that assistance now from Dr. Nye. Dr. Nye started looking at this case to review the opinions of others, and we're not asking the court to even consider that piece of what she did, because she then went on to do her own investigation. She did her own visit to this scene. She did her own consideration of the wound pattern. She did her own force calculations. The court has her map on her notes where she went through and actually figured this out, figured out the force that would have been required to fall from a standing height, from a kneeling height, figured out the force that would have been required and the direction of the force that would have been required for this to have happened in different ways. And from that biomechanical evaluation, she told the court that the only hypothesis that she can't disprove is that this was an accident. And there is no other biomechanical evidence before this court. If the state wanted to call a biomechanical engineer, or really any witness, to say that Dr. Nye was wrong, they could have done that. That's not what they did. Dr. Nye testified without any opposition. Dr. Cruz said, I really can't speak to those issues. And that's testimony the court has to consider in deciding what the state of the evidence is here. I'll go through the other evidence the court heard briefly, because the medical evidence is the most important. The court heard that despite at trial, the unrebutted testimony, save for from Mr. Mullis, was that all these searches were from the iPad and that they were very nefarious. And when the court actually gets a chance to see that those searches didn't come from the iPad, that many of them came from other devices, and the actual content of the search, that these searches are related to hunting tests, they're related to television programs. The actual content of the searches and the evidence that they didn't come from the iPad tells you that Todd's testimony was right. The court will have a chance to look at all of these texts and emails which are in evidence, and the court heard from Mr. Safarik and others about what all of this electronic evidence means. And it proves what Todd said, which is that even though his wife was having an affair, this had not bled over into the marriage, that he didn't know about it, that they were living relatively happily, despite the fact that there were sometimes, disputes with a mother-in-law. None of this was creating this situation that resulted in some planning to end someone's wife's life. I mean, there are text messages with Todd right up until the end of Ms. Mullis's life where she's saying, I love you. The court has Tristan's testimony, and it should evaluate it, that Tristan has explained why he testified as he did, and that his dad was really only out of his sight for a short time. The court knows about the 911 call. It heard a lot about that, about the discovery violation that occurred there, and that this was a trial by ambush with respect to this 911 call, and that 911 call is not what the state described, and that Todd was with other people, sheriffs, when that happened. There's a lot of other claims that counsel presented, and the court knows what the evidence about that is. Based on the evidence the court has, it knows that Todd's established his Sixth Amendment claims, it knows he's established an actual innocence claim, and that this is the rare case where, considering these claims separately or cumulatively, that a new trial is really the only fair outcome. I'm going to come back and talk in rebuttal in a minute, but based on what the court's heard, there's no doubt that Mr. Mullis's trial was unfair, and there's just one result from that, Your Honor, which is a new trial.
Thank you, Ms. Thompson. Closing argument on behalf of the state.
Thank you, Your Honor. May it please the court. Good afternoon. I will be brief. The state submits that Mr. Mullis has not met his burden of proof on any of his claims. We ask the court to deny his application in its entirety. In addition to the record and issues that have already been developed at trial and before it in this proceeding, we will address our legal reasoning for why each of his claims fail in our written brief. Thank you.
Thank you, counsel. Your final rebuttal.
I just want to add one more thing, which is that although we believe that we've established Mr. Mullis's actual innocence, which means that there should not be any new trial, if the state concludes that they want to rely on Dr. Cruz and retry him, that's an opportunity that he should have an opportunity to present this evidence to the jury. Because the last thing I'll say about this is the court may conclude in looking at all of the evidence, both what it heard here, what it reads in the record, and it may determine, well, I see some evidence on the other side. I see some evidence still that for me, I don't know what to make of that. I see that the state made some arguments at the original trial, and for me, I don't know where I end up on actual innocence. The court can have questions as a result of this hearing about what happened, but as the court knows, those questions are the province of the jury. It is for the jury to decide if it believes Mr. Mullis. It's for the jury to decide if it believes this other evidence, but this is all evidence that the jury should hear. Because Mr. Mullis has established there is at least a reasonable likelihood that the outcome of this trial would have been different, with the overwhelming evidence that the court has seen, that it has read and will read, that it's heard. This is evidence of an innocent man. This is evidence of a man that deserves a new trial and a trial where he can have his day in court. And for that reason, Your Honor, we're asking the court to grant Mr. Mullis a new trial, and we'll provide additional legal briefing in the post-trial briefing that we make in a month, Your Honor. Thank you.
Thank you, counsel. I will await both parties' final briefing by the April date that we previously discussed. At that point, I will consider the matter finally submitted. Counsel, if you maybe just want to touch base with me briefly in chambers before you leave so that we can make sure that everybody is on the same page as far as the exhibits that were admitted. And then I'll give you a day or two just to review any final security level issues before I file the exhibit management order. Other than that, anything that we need to address before we go off the record? Anything on behalf of the applicant?
No, Your Honor.
Okay. Anything on behalf of the state? All right. Thank you all for appearing and for your cooperation to keep things moving throughout the trial these past days. Thank you.
Okay. I guess that's it. I guess we have to wait until after April 8th to find out what her decision is going to be. That sucks. That's like a month away or more. Jeez Louise. I don't know. Somebody asked, I think it was Michelle. Yeah, Michelle asked a while ago, any word from Morgana? I don't know. Let me look in the mod chat real quick. Let's see. So I haven't heard from her today. Nothing from her in there today. But more than likely, she's over there in the Karen Reed shenanigans. That's probably where she be. Because I know that Karen Reed had a hearing today. This morning. I think it started at 9. So that's probably where her eyeballs are glued. So she's not invested in this case at all. But she's heavily invested in Karen Reed stuff. So anyway, today's a short day, huh? Today's a short day. All right, I'll take it. I'll take short days. Miss King, I actually turned that on earlier. I saw it on one of the local to that area. I know, Kel, right? We have to wait until April 8th. But Miss King, I did see that. Awful, man. Awful. I had just gotten into the opening statements this morning. I was watching some of that whenever kiddos' virtual class was going on, so I haven't got to watch all of it, but the Swan Club trial is interesting. Swan Boat Club. Oh no, Margaret, math isn't until 1. But you did miss reading and phonics. Or no, just reading today. So, yeah. You missed it. Altogether, you missed it. Let me go see who is... let me go look. Hold on a minute, y'all. So the Karen Reed hearing is still going on. I wanted to check out that house fire homicide, but I don't know anything about it. I started, what was it, yesterday, late? Hold on a second, I was looking. So it doesn't look like Court TV or Law and Crime are streaming the Swan Boat Club one. But like I said, I saw that. It came across my feed, and I watched it on whatever local to them channel station that was. And that judge is like, rawr. He's snipey. I might like him. I don't know. But you're also heavily invested in Karen Reed, Miss King. Yeah, I think a lot of people are. I'm wondering what's going to happen because I've not been able to catch all of the things. I need Morgana to come fill us in soon. So, but I'm going to go ahead and jump out of here for today, I think, since it's an early day. Kel, yay! Kel said, I've caught up on all episodes of Paradise. It's so good. Another episode comes out today. Yes. I know, I've been waiting. I've been waiting for a girl like you. Now tell me, Kel, tell me lies. Tell me sweet little lies. Sorry. That is how my brain works. Maybe that's one reason why I love that series so much, Kel, is because my brain and all of the 80s music and the throwbacks in that show, like, oh, I just mesh so well with all of the things in that, all of the 80s stuff in that TV series. It's amazing. I love it so much. And I told my husband whenever I was trying to talk him, I said, he's the one that told me about it. But then he only watched one episode, didn't even finish an episode. He watched part of an episode and then fell asleep or went to bed, and I kept watching, and then I kept watching and kept watching, and I binged like 5 or 6 episodes back to back to back to back that first night. And the next day I told him, I'm like, you have got to watch this series. The music is incredible. But the show itself, all the characters have massive personalities. And I don't know, it's been a really good series so far. So, yes, Henny, I hope you watch it. And if anybody else here, oh, it's so good. The TV show is so good. It's hard for me to watch Karen Reed. The prosecutor makes me mad. I know. Rawr. Rawr, rawr, rawr. I missed math class. Now it's time for... But I'm on time for music. I binged this weekend and was disappointed that I caught up. I didn't know all episodes hadn't been released. Yeah, I know. I'm usually late to good shows, so that don't usually happen. I know. I hate it whenever I have to wait. Oof. I'm too impatient. I like to binge like all of it. I don't want to have to wait for a week and a week and a week and a week. It was that way too with the Dragon show. I can't even remember what that show was called. I forget now. Okay. Lioness is really good too. House of the Dragon. There we go. Yeah. That's it. Thank you for hanging out with us today, Gail. Thank you. Thank you. All right, you guys, I'm going to go. I'm going to go. I don't know what we'll have on tap for tomorrow at the cafe. But I'll take a look at some of the different trials that are going on and kind of see where we're at and kind of go from there. If you guys want to leave me a comment, I know that Morgana said there was another Karen Reed hearing coming up. I think she said they were going to be in court 3 days this week. So I need to go look and see. Ooh. Maybe we'll check out the Karen Reed hearing, depending on what's going on. So, but you guys have a great night. I'm gonna go get her prepared here in a little bit. She's still got about 40 minutes before her math class starts, but that'll give me time to go get some stuff done and get her ready for math. And then, yeah, I don't know. I'll probably catch up on some of these trials that are starting. That the Swan Boat one, and then that house fire one. I don't know. I'm kind of like, what is that? I need to check that one out. So you guys have a great rest of your day. I know it's early, but yeah, we'll see you tomorrow. All right. I'm going to take advantage of an early day. So love you guys, and I will see you back tomorrow. Make sure to subscribe if you're new. Hit that notification bell. Click that thumbs up button before you leave. And hashtag replay in the comments down below if you're watching this on the replay. All right, folks. We'll see you tomorrow. Love you. Bye.